Good evening. My name is Phil Schomber. I'm the adult programmer here at Hedberg. I want to thank everyone for coming and joining us for our program tonight. It's my pleasure to be able to introduce our speakers, Alexis Camacho-Stedman and Stroede. They're both with Legal Action, and they're going to be talking a little bit about the process of eviction, as well as the adverse effects of eviction and the legal services that are needed here in Rock County. But before we delve into that discussion, tonight's program is co-sponsored by the League of Women Voters of Janesville, and I'm going to hand it over to Mary Bulow to talk a little bit before we jump into the program.
Thank you. Can't talk that loud. Okay, my name is Mary Bulow, and I am with the Janesville League of Women Voters. And the League of Women Voters is a nonpartisan political organization that encourages informed and active participation in government. The League's members study a wide variety of issues to see where we might promote better policies and outcomes in our community. Housing is one of those issues. For many people, housing means renting a place to live, but sometimes a rental arrangement goes wrong, and the renter receives a court order to vacate their home, otherwise known as an eviction notice. No matter what the reason for the eviction, the experience of being evicted is traumatic. There are impacts that reach far beyond finding a new place to live. We are here tonight to learn from Legal Action about those adverse effects, how eviction actually works here in Rock County, and the need for legal assistance and what services they provide. The Janesville League of Women Voters extends our thanks to our presenters tonight and to the Hedberg Public Library for hosting this program. Thank you.
Thank you, everybody, for having us. I wanted to kind of get started by introducing myself. So my name is Alexis Camacho-Stedman. I'm an outreach paralegal with Legal Action of Wisconsin's Madison office, but Aaron and I specifically work only with Rock County residents dealing with landlord-tenant issues. Aaron, I don't know if you want to introduce.
Sure, yeah, just a bit about me. My name is Stroede. I'm from Wisconsin Dells, Wisconsin. I graduated from UW-Madison Law School, and I did some private practice at a private firm in northern Wisconsin before coming to Legal Action.
I'm from Janesville, just so you all know that you have a local here. So before we get started, I wanted to kind of talk a little bit on some background about Legal Action. So
I was going to introduce Legal Action. So we've been around since the early 1950s. We serve the lower counties of Wisconsin, and we offer 7 different areas of civil legal services, but I'm here mainly to talk about housing. So many of you probably already know, in civil court, you don't have the right to an attorney like you do in a criminal court. So we offer legal representation to low-income people at no cost to the client. Tenants are rarely represented in eviction proceedings, and landlords usually are, so we're just here to help level that playing field because it's much needed here. So some goals of the Rock County Housing Stability Project. This is the project that Aaron and I are working under. Little background. The goals obviously are to secure safe and affordable housing, to prevent homelessness and evictions, and secure and protect tenants' rights to public and subsidized housing as well. So if you're here today, I'm sure most of you already know that many low-income people spend at least 50% or more of their income on rent or household expenses. And according to HUD, the U.S. Department of Housing and Urban Development, they recommend that the total housing costs of a household does not exceed 30% of household income. So if it does, your household is considered cost-burdened. So that often means that one financial setback can really screw somebody up. So if you lose your job, your car breaks down, you have unexpected medical expenses, it can make it hard or almost impossible to make a rental payment sometimes. So people often lose much of their personal property, sending things into storage facilities and things like that, or paying moving costs. They spend hundreds and thousands of dollars often just getting their things back, and often end up paying court costs and fees. So eviction is not cheap for anybody. Oh yeah, before we jump into this, I forgot I also wanted to point out, so the Janesville Housing Affordability Report and Analysis of 2020 and the Beloit one of 2021, both indicated that there is a serious mismatch in rental supply and demand in Rat County. So this leads to a huge disconnect in housing affordability and housing quality. So the increase in demand has exceeded the supply, which has led to this large increase in housing prices. And also people paying higher prices for lower quality rentals as well. So in the 2019 analysis of impediments to fair housing in Rat County, Beloit and Janesville both indicated that a healthy vacancy rate for rental properties is between 7 and 8%, and Janesville's is 1%. So that's extremely high. And also HUD defines fair market rent as of 2021 for a one-bedroom apartment is $656 a month. So I think anybody, if you just do a quick Google search right now, it's almost impossible to find something 1 to 2 bedrooms under $1,000 or $900 even. So our goals here are basically to help families avoid housing instability while also allowing rental properties to run effectively, because this is vital to the stabilization of our communities. And not only this, we want to help make this kind of knowledge more accessible to people as well, and have people feel comfortable coming to us to ask questions. So the issues that Erin and I can assist with are, I'm going to speak briefly about a few of these. So evictions are the call we receive the most of. So if it's early enough, we can help people negotiate with their landlord if they've just received a written notice, so they can figure out what the issue is and hopefully establish a solution to that, whether it's a payment plan or obtaining rental assistance or solving some other breach.
Yeah, and prevent a filing from even occurring.
Yes, because if it gets to that point where an eviction is filed, that's on your record, and depending on if it's granted, it can be on your record for 2 to 20 years, which really can affect your ability to find housing. So other than evictions, we can also help people with conditions problems, so kind of assisting people and walking them through problems, how to document when you're dealing with conditions issues and what your options are, basically. We can also assist people with security deposits, so if your security deposit is withheld, we can help you determine whether or not that was done so lawfully. We can also assist with redactions, so if you do have an eviction on your record that doesn't have a money judgment attached to it, preferably, it's a lot easier to help get that redacted. If it hasn't been satisfied, I think it makes it a lot harder.
And when we say redacted, it means to remove it from the CCAP website, so people searching your name won't be able to see that you've had an eviction in the past.
Finally, we can also help with lockouts or self-help evictions. So that's when a landlord just shuts off utilities or changes the locks without going through the court process. So I wanted to talk a little bit about notices. So there's different types of notices that you can receive, these written notices. So you can, depending on your type of lease, you can receive a 5-day notice to pay rent or for breaking the lease. You can also receive a 14-day notice, as well as a 28-day notice for no reason. Those are more commonly referred to as non-renewals. And then there's also a 5-day notice that can be issued if they think you did some criminal activity. So a lease can be verbal or written. It can be for any length of time. It's most common is a year or a month-to-month lease. There are other types of leases, though. So if you have a lease agreement that is expired, typically, if your initial rental agreement will kind of explain how you would go about renewing another lease, or if it's going to grandfather over into a month-to-month lease, or basically what steps you need to take to extend your tenancy.
And the duration of the tenancy of your lease or rental agreement kind of dictates what kind of notices your landlord can give you for a breach of the lease, or if they're even able to non-renew you. For example, if you have a year lease, you can't be non-renewed during that term, so you can't, during the term of your lease, you cannot be evicted for anything except for breach of the lease or violating some term of the agreement for non-payment of rent or criminal activity or something along those lines.
So like I was kind of already saying, the eviction is the legal process that removes a renter from their home. Process starts with a written notice, which is dependent on your lease, and then if the renter does not leave the home or cure whatever the issue is, the landlord can then file an eviction in the court, which starts the official court process. And if the landlord wins this court battle, then the sheriff will eventually be sent to the court to remove the family and their belongings. So to kind of visualize what that looks like, here's a timeline. So the notice I'm referring to is the written notice. So however long the length of time is, that notice will expire. Then the landlord can start the eviction process in the court.
A common misconception with that too is that a lot of tenants we find will be issued a notice, whether it be a 5-day, 28-day, whatever, and they think that the sheriff will show up on the end of that notice period. That's not true. The landlord has to go to the court to get an eviction and have the sheriff remove you from the property.
So once the eviction is filed, they'll schedule a return date, and this must not be less than 5 days, nor more than 25 days from the date on which the summons is issued. And then additionally, the tenant must be served at least 5 days prior to the court date, the summons and complaint and all that information. But there isn't anybody policing that information, so if you didn't know, you might not be able to raise that later, that they didn't follow the proper statutory requirements. Hearings are typically scheduled within 30 days of the return date as well, so if you do have a defense to present, they'll schedule a hearing within 30 days. In Rat County, trials are scheduled on Friday, and your return dates will typically be on Wednesday, and it's always in front of the court commissioner as well. They're typically over Zoom right now, so this is an example of what a notice of hearing looks like. So if you'll notice that they have all this like Zoom information and such, so it'll give you an option to, you can either join by going online, or you can just call in on your phone as well. But you do have to attend. It is required. If you don't attend, it can be an automatic judgment can be granted in favor of your landlord. So if you did want to raise any defense, it's important to attend your return date and do it then. So to understand your defenses, I wanted to talk a little bit about basic landlord duties and prohibitions. So a landlord is required to tell you if there's any maintenance before you move into the property, any ongoing maintenance problems or pest control problems upon move-in. So this is often very hard to prove that they knew about an existing problem, so that's why we recommend that people always do move-in inspection reports and keep a copy of your move-in inspection report. Because your landlord will obviously take the inspection report once it's done. Always make sure you at least take a picture of it or take a copy somehow so you have that for your own files, as well as your lease. So make sure you always can access your lease. Because unfortunately we've had that a couple times where people just don't have a copy of it, and it sucks. Another duty of the landlord is repairs. So the landlord is required more or less to keep the dwelling in repair and up to standards. And if you are also required to inform your landlord if there's anything that needs repairs. And we always recommend that people do this in written format, because oftentimes, landlords will say, oh, I didn't know about that. So always keep good record of everything that you have and any correspondence that you have with the landlord. So like screenshots of text messages, or even just recording dates that you had a phone call or a voicemail can work. Just documentation. Also, to address repairs, they have to give you 12 hours of notice of entry before they enter your unit, unless sometimes there's emergencies like gas leaks and stuff like that, then they don't have to give you notice. And finally, they do have to return your security deposit. If they do not, they need to provide you with an itemized ledger within 21 days of moving out. That details for everything they're withholding your deposit. Sometimes they withhold your deposit for things they're not allowed to, so it is kind of nice to at least know that you're getting everything back that you should be getting back.
Question with those too that comes up a lot is, well, can they withhold past rent? And that they can. So.
Some prohibitions for landlords, so they can't obviously illegally evict you without going through the court process. This includes shutting off utilities and changing your locks.
Or we've seen removing doors entirely too. So.
Retaliation is something that landlords aren't permitted to do as well. So this would be like if you reported a conditions problem and your landlord gave you a notice for reporting a conditions problem. However, the issue with this is it's extremely hard to prove.
Well, yeah, essentially, retaliation, you really only have retaliation as a defense if there is no other valid reason for the landlord to evict you. So if you think that because you contacted the housing authorities about a condition you're facing, and your landlord might be retaliating against you by issuing you a notice to vacate. That will not be considered retaliation if you're in default of rent at that time as well, or you're breaching the lease in some other material way. So, and just to kind of go off of that too, retaliatory action on the part of the landlord could also include, it can go beyond just filing for eviction or issuing a notice terminating tenancy. It could include increasing your rent or decreasing services, or even a refusal to enter into a new lease or renew a lease with you. So it goes beyond just retaliation through evicting you. So
A landlord can also not misrepresent the unit they're showing. So like you can't tour a unit that you're not going to rent. They can't, false advertise, basically. Some defenses you can raise at your return date. So can be kind of a confusing process. And your first instinct at a return date might be to say, well, I didn't pay rent, or I only paid partial rent because I was dealing with conditions problems. And that's not a defense that you can raise at an eviction return date. So if you do plan on saying something like, I don't believe I owe these late fees or utility bills, you need to make sure that you have like a copy of your lease or your bank statement, something that proves that the landlord is wrong in this instance. But here are some things that you can look out for just to know off the top of your head. If you receive a notice, or you must receive a notice, I should say, in order to be formally evicted. So if you didn't receive a notice once you get to your return date, that's something you could bring up. You also the notice has to be done correctly. So like I said, the landlord has to adhere to certain statutory requirements. So if they didn't adhere to some of those, that might be another defense you could point out. Landlords also have to follow the correct timeline. So like I said, 5 days and 28 days, 14 days, those notices, once they expire, that's when they can start the court process. Sometimes they break those rules. Sometimes they'll file an eviction before that 5-day notice expires. So if you discover that they've done that, that's another defense you could raise. If you agree with a notice, so like if they say you're behind on rent and you are behind on rent, you can possibly have the option to reach out to your landlord and pay that amount to rectify the situation and prevent them from filing for an eviction. If you disagree with the notice, like for instance, they charged you like the wrong amount, you can pay what you think you were supposed to be owed. But doing that kind of opens you up for potentially them filing an eviction then for non-payment of rent. So if you do choose to do that, you do so with that knowledge in mind.
Yeah, and you can always dispute the amount of money owed in a notice for non-payment too.
So what happens if and when an eviction is granted? So at your return date, you'll receive a judgment.
If you don't raise a valid legal defense, yes. Otherwise, like Alexis mentioned earlier, if you do raise a valid defense at the first hearing, which is the return date, the commissioner will set it for hearing in front of a judge, and that's when you'll present your evidence. But if the judge or the commissioner find that that the landlord is entitled to an eviction to regain possession of the premises, this is what happens afterwards.
So basically, if an eviction is granted, there's something called a writ is issued.
Yeah, and a writ just basically is a court order directing some official to either take or withhold from taking a certain action. So a writ of restitution is what happens in eviction court, and that just directs the sheriff to regain possession of the unit for the property owner.
So then after this hearing, the landlord will then have to take their writ to the sheriff's office, and then the sheriff will, sometimes it's anywhere from 2 to 5 days. You can always call the sheriff's office and ask when they plan on executing a writ, but you might have a couple number of days, and then the sheriff will serve the writ, and that's when it will be carried out, and you may or may not be, be removed from the property, unfortunately.
And just in my own experience with Rock County sheriffs, they've told me that they'll execute on a writ 2 days after they receive it, and they typically give notice to the tenant, but they're not required to do so. As soon as they receive the writ, they do have the authority to come and remove you from the premises.
So what options do you have if you've received a notice for non-payment of rent and you don't know what to do because you can't pay rent? First step should always be to reach out to your landlord, kind of explain what's going on. You know, sometimes we're all humans, so sometimes people can be sympathetic. Like if you lost your job or something's happening, you can arrange a payment plan or something, work something out. If you do this, make sure you get it in writing. Always keep documentation of this conversation so you can look back on it if they do end up filing for an eviction. You can also apply for rental assistance. So there's emergency rental assistance through Community Action and ECHO that you can apply for. And they will often catch you up on back rent as well. So that's an option if you owe back rent. It's not just for future. Some other options that you do have, you can file for bankruptcy, which kind of does like a stay, right, on the eviction proceedings. And if you are a member of a protected class, you can ask for a reasonable accommodation at your return date. So this is referred to as a stay, and it will give you an extra 30 days in the court process. Let's see here. So if you do end up being able to come up with the money after a notice is issued, a landlord is not required to accept payment after the notice expires. They can still file for an eviction, so that's why we always recommend making sure you document any kind of agreement that they may have agreed to previously. If you think you do not owe the full amount, like I touched on a little bit before, you can pay the amount of what you think you do owe and maybe communicate with your landlord a little and hopefully work something out on why. Yeah. Let's see. I'm also going to talk a little bit about rent abatement. So rent abatement means paying less than the full amount. You should never abate your entire rent. That's basically inviting an eviction, unfortunately. So if your apartment or your unit is uninhabitable, you can abate your rent in certain amounts. A lot of cities will have different ordinances that they can follow. So like if your heat doesn't work, you can abate your rent by 20%. Or if your
infestation, 25%.
Yeah.
Yep.
So there are certain guidelines that you're generally supposed to adhere to, so you can bring those up. But also, if you abate your rent, that's still kind of putting yourself at a risk if your landlord disagrees with that or you don't have proper documentation or proof backing up your claim, so they can file for an eviction for non-payment still. And so it's just a tough spot.
Essentially, at that point, it's left up to the court to decide whether or not the amount abated was reasonable under the circumstances. And I know that's pretty vague, but you know, we look to, and like Alexis said, there's cities that have ordinances that kind of dictate that amount. So those are good guidelines to kind of base the amount you're choosing to abate off of.
So it's really up to your personal discretion if you would like to risk doing abatement and then.
Yeah. And because it is such a tricky process, we do suggest that you reach out to either us or an attorney to kind of counsel you through the abatement process. It is a tricky area. Just given the standard that something that you're only entitled to withhold a reasonable amount, well, you know what's reasonable. So that's why I suggest that you seek counsel if you can.
Mm-hmm. So like I was saying, sometimes people will want to abate their rent fully. So if you do that, you have to move out of the property, and the conditions have to be very bad. We also recommend advising people to get a city inspector to come out and do an inspection if they haven't yet, because if the conditions are, you know, not atrocious enough, it's just nice to have that extra documentation to support your conditions claim. But you might take that risk if the conditions are super horrible. There's a possibility it could get condemned, and you don't really want to get stuck in a situation like that either. So again, it's a very tricky situation.
And in that situation, it's called a constructive eviction. That's just the legal term for it. And constructive evictions really only happen when the premises is pretty much uninhabitable. So for example, you know, that you have a hole in your roof and you can see skylight. That's a pretty good example of where your unit would be uninhabitable at that point. Another thing, these tough, you know, Wisconsin winters, if your heating is completely off, and that would be another example where, you know, you can you can leave the premises, and then that would relieve your obligation to pay rent in that circumstance.
Some other resources that I wanted to make sure I talked about. So like I said before, like if you have ever felt like you're discriminated against and you wanted to file a complaint, you can do so with HUD. So they have a fair housing and equal opportunity hotline that you can call. DATCAP is also an option, the Department of Agriculture and Consumer Protection. So this is more of like an informal database where you could write like a complaint letter and your landlord will be
Informed, and they're given the opportunity to respond to, and you can see the response. And depending on that, the department will decide whether to issue a warning or to pursue an action on their own.
And you can also reach out to the Equal Rights Division as well. That's a complaint form that you can reach. If you just Google Equal Rights Division discrimination complaint landlord, you should be able to find it. But that's the number of the form as well. I also did want to point out, so a lot of people often say they received an eviction notice in a discriminatory way, and that is also not a valid legal defense, unfortunately, that you could raise at your return date. And many people think that you can. Also wanted to point out a couple other upcoming presentations that we have. We have, it's very similar to the presentation we're doing right now. It's a Know Your Rights series, so it's going to be on Saturday, October 22nd, November 5th, and November 19th. And at each session, we'll be going over 5 additional questions. And I also do have a couple packets on the back table there with those questions all that we'll be going through. And if you'd like another copy, I can send that to you as well. If you are looking to just kind of walk in and get some advice, or if you need an attorney and think we can help you, you can come into our walk-in hours at Echo from 9 to 11, that's Monday through Wednesday. And I'm also here at Hedberg every Thursday from 3 to 7 as well. And then anytime you can also call our intake line, which is listed here. That's the number you can also call if you wanted to obtain any of our other legal services that Legal Action provides outside of what Erin and I offer. So that's like family law, consumer law, some things maintaining public benefits. What else? We also have a farm workers project and an elder rights project as well. See, and I think lastly, I have our website where you can learn a little bit more about legal action broadly if you're interested, and also our emails, or you can send us any questions. That number there is my work cell phone. You can call and leave any questions that you have related to landlord-tenant issues, and depending on the severity of the issue, I'll get back to you as soon as I can. Yeah. That's all I have. If anybody has any questions, I will open it up. Yeah, I think Phil is going to bring the microphone over to you, I think.
The best thing you can do is to contact the landlord and try to work it out before they, I mean, if you know your rent's going to be late, you don't need to wait till the 1st. You might know that on maybe the 15th, and most landlords aren't out to get rid of the tenant because
Right.
they lose rent. So if you work it out with them, both people are a lot happier.
Exactly. Yep, that's what we want to avoid, getting it to the court process and where it stays on people's record for
Yeah.
a very long
Yep.
Yeah,
time.
and then it's on your record, and your future landlord will probably look at that and
Yes.
not want to rent you.
And it
Yes.
saves both parties
Yeah.
considerable
The
time
best
and money.
is try to
so.
get along.
Yes, and we've already noticed that even with a pending eviction on your record, some places won't rent to you. So we've even tried calling on behalf of clients and saying, hey, this is the situation. They're a great tenant, never been behind on rent before, and they still said, sorry.
But once the landlord pays that money and goes through that, they usually keep going.
Yeah,
Get them ticked off enough.
yeah.
Yeah.
You mentioned various, is that the main way to negotiate or remediate? So if you are in a situation and you don't want that eviction on your record, what kind of things can people try to work with their landlord to make sure that doesn't happen?
Sure. Yeah, you can get as creative as you want with it. Beside, over and above just your typical payment plan, if there's a specific concerning behavior on either the tenant or the landlord's part that either party would rather not happen, or have some sort of term built into like a new lease, because a lot of parties will run into these problems when they're on a month-to-month lease or a month-to-month rental agreement. You could, and I hesitate because some terms of lease or proposed terms can be unenforceable under Wisconsin statutes. But if there's a certain behavior, say that a tenant is smoking in a certain area and the landlord doesn't want that to happen, you could build that into the lease. You're not restricted to just the form leases that you can find online. So.
I was surprised when you said that a lease can be either verbal or written. The verbal part surprised me.
Mm-hmm.
Can you talk more about that?
Yeah, so typically a verbal lease is mainly just like the date you have to pay and the amount, and that's pretty much it, and that's considered a lease agreement.
Yep.
How can you stand up in court?
Well, there's plenty of contracts out there that are enforceable in court just through word of mouth, especially if one party relies on that agreement, that verbal agreement. If one party, so I would say, if I was told that I could rent a place and we agreed, I gave a security deposit and I moved all my stuff in there, and then the landlord wants to come back and say that we never had a valid lease agreement. If a court would uphold that or enforce that agreement, although it is harder to prove because there is no writing, but verbal contracts do happen all the time, and the realm of landlord-tenant law is no exception to that.
You mentioned that some of the legal work or the proceedings are done over the phone.
Mm-hmm.
Suppose you don't have a phone that can handle that.
I think, so if I'm not mistaken, there's a line on here, so you can call the clerk of court's office. Well, I suppose you'd have to figure out how you're going to do so. You could go to the clerk of court's office and then, I think, ask for an accommodation, if I'm not mistaken.
Yeah, that's something you can do, and they do still take people in the courtroom, so if you show up on that date, then you will be considered as making an appearance in that case, but they do prefer over Zoom or over phone.
Suppose the tenant above you in an apartment drills a hole down one of your walls so that you can't see it from inside the apartment, but there's a hole down the wall. And it's not fixed. What do you do?
Yeah, I would speak to your landlord first about that.
Okay, well, that's been done. And it's not repaired yet. There's a whole lot of things going on with my apartment that I should be probably discussing with you.
Yeah, sure. We got time afterwards if you want to talk in private too. That's something.
You also mentioned that you're at Echo. You mean you have an office at Echo?
Yes.
Okay.
And
So
our office hours there are 9 to 11,
Yes.
5 days a week.
Monday.
Just
through
Monday
Wednesday.
through Wednesday, and then I'm here on Thursdays.
Any other questions? Yes.
Also, if you think of any questions that you don't want to ask out loud, you can also write them on a Post-it note over there too, and then I can answer them
Yeah.
too. If you put your email.
Okay, I wanted to know about what records will show when a person is evicted, or you mentioned pre-eviction. Where do people look for that? And who can access those records? And you mentioned anywhere from 2 to 20 years. Now, I know CCAP, but are there other places that people look? Does it show on the credit records? Tell me more.
Credit records?
Yeah, it would show up if there was a judgment and then the plaintiff tried to enforce that judgment against you. And if they report to a credit agency, it could appear on your credit record. Regarding the eviction itself, it is public record. It's available on CCAP. I know Wisconsin has kind of one of the most accessible records to the public through the CCAP website. It's also available to parties if they wanted to just go to the courthouse and ask for the specific documents in this court case. It's readily available in that way as well. So when an eviction is filed and pending, it'll show up right away. You know, sometimes I'll, if I feel like that a landlord might file against a client of mine, I'll browse CCAP, and sometimes I know it before the tenant does too. So it's accessible as soon as the landlord pays the filing fee and submits a summons and complaint. Now, how long it stays on CCAP is kind of, it depends on the outcome of the case. If it's dismissed, it'll be removed after 2 years. But if it's granted and there's a money judgment in cases of non-payment of rent, or if the landlord comes back and wants to claim some sort of damages and there's a judgment on record, it'll last up to 20 years. And the only way to remove it then at that point is through a motion to seal or redact. And that's something, it's not easy for somebody with very little legal experience to pursue that option. But one of our projects is to make it more accessible to the general public too. So again, you can call us, and we can, we provide a wide range of services from advice all the way to full representation.
One thing about those, pretend you go to court and you get the eviction, and then you go back for rent and damages and you get that, pretend, I don't know, $1,000. That collects interest quite a bit annually, and until you pay that, and then you can get a satisfaction, a judgment if you paid it in full, but that, you can't remove that till that judgment's paid. Some people try to go in there and want to forget it. It don't work that way.
That's correct, yeah. And we should probably mention just briefly about the damages portion of these eviction processes as well. After, as Alexis noted, that the hearing has to be held 30 days from the return date, and that's just to hear the eviction. If an eviction is granted, then usually if the landlord wants, they can hold it open for damages, and then there'll be a damages hearing at a further date too. And it's my understanding that here in Rock County, they're still holding those over Zoom or the phone as well. But yeah.
The other thing is, you mentioned, pretend you got something wrong in your house, the heat don't work, or you want this rent abatement. Best thing to do before you call a building inspector is really work it out with the landlord, because once they call the building inspector, even in a brand new house, they can find 20 things wrong minimum.
Oh, yeah.
So once they come in, pretend he says, oh, this paint is peeling, we need that done. They'll give the landlord so many days. Well, landlord calls the painting contractor, he might want to show up at 7 in the morning, and you got your 24-hour notice that
True.
you don't care what your schedule is,
Right.
you're going to get the work done.
And that's what we generally advise as well, is to talk to the landlord first. Especially, if we kind of anticipate that an eviction might be filed due to less than a full payment of rent, and we intend to use a rent abatement defense in that case, it's more convincing to a judge if the tenant has spoken with the landlord prior to it as well. So it's only after you tried speaking and working it out with your landlord that rent abatement really becomes an option. So yeah.
Landlord just is impossible.
Right.
Most of them aren't, or they won't tell their tenant.
So what I'm hearing here is it's not just the legal rights that someone has and legal options, but it's also negotiating and make nice and trying to work with the person you want to help you out.
Yeah, exactly. And in court too, that's what the judge will look at too. I mean, they might not say it, but they'll see the certain steps that each party has taken to try to solve this on their own. And while it might not be a legal argument, it does kind of have an effect, I think, too. So.
What are options for people who are evicted? As far as finding
If you have nowhere to go, Alexis, if you want to.
Well, So you can, it's tough, that situation. So, and it's often a really hard spot to tell somebody that they do have to vacate their property. When we do find ourselves in that situation, I feel that I turn towards ECHO or the YWCA, any kind of temporary housing, House of Mercy, Greater Family Promise of Beloit. Next door, Family Services has a new transitional living facility in Beloit that they just opened up. I think it has 17 apartments and they're going to house families. So resources like that, I mean, I know a lot of times people don't like to hear that information, but also a lot of times if we want to get a redaction granted right away so people can find housing easier, it's better to get somebody out of their unit and somewhere temporary so that we can get our redaction filed immediately, and then they can have an easier time finding somewhere to go as soon as possible. It is a tough spot to be in, but sometimes that's the best option.
Yeah, I mean, those are all great resources, but they're limited too. So.
Yeah, especially when you have places, like when people have Section 8 vouchers, you know, a lot of times they'll say absolutely no evictions applications with Section 8 vouchers, and that's another hurdle. So it is tough. But we also do tell people to like document, you know, any fees they spent on rental applications that they end up getting rejected. That's all things you can put towards supporting your asking to have your name redacted.
Right. Do you have a question?
No. Okay, each year I hear about unavailability of apartments or housing. And I know for a fact that this state has Fort McCoy. And Fort McCoy, I've been there, it has many housing units. They're World War II housing units, barracks. And as you know, we have a large influx of immigrants into this country. I don't see this capability of the Fort McCoy being used, and I think it could be used for both Americans and the immigrants, or either or. But is there some restriction why we can't use that housing at Fort McCoy?
That's a good question, and I do not know the answer, but I can look into it. Do you know anything about Fort McCoy? I do not.
No.
It's a resource that we should use as
Yeah.
a state.
Okay. Yeah, I'll look into that. I'm going to write that down. Thank you.
So I just want to do a caveat of what she said as to why to like kind of work with your landlord, because it also can be really costly on their end. And I'm just wondering, do you know the average cost of an eviction on the landlord's end?
Ooh, you might know.
Well, let's see, it kind of depends a lot, but I mean, there's fees associated with going through the court system, and you know, if they use an attorney, those fees add up really quickly. But you know, just in terms if they choose to do it by themselves, there's a filing fee and then service fees, and that can run, you know, a few $100s just right off the bat too. And not to mention, if they are looking to re-rent too, that's an opportunity cost where, you know, the tenant, you know, may otherwise vacate on an agreement. They're essentially holding over, and that's money that could have been gained by the landlord had they re-rented the unit. So there's always those sort of considerations, and you know, if the landlord doesn't deliver proper notice and the eviction ends up getting dismissed, it can be months before they're granted an eviction. So.
That could be an argument that you can have with them, not argument, but like come to terms, I guess, where you might save them some money by not going through the eviction process, because it can be very costly.
Definitely. And I mean, just a kind of like a tip for negotiating in general, it's, you may not want to lead with that.
But if it comes to like the very end, like,
yeah.
getting very close.
Right. And you know, it's a lot of time for both parties too. So.
Also, they can't charge you for court fees retroactively, right? Like the landlord can't.
It depends. It can't be in the lease that you're liable for any court fees. So they're not entitled to those right off the bat for, any sort of eviction filing. They have to demonstrate in the court why they're entitled to attorney's fees. So.
And if it's worked into the lease, then they can buy.
That's a very interesting situation because technically it makes the whole lease unenforceable, which has a lot of legal meaning that, if you want to talk more about it at some other time, I'd be willing to. But when a lease is unenforceable, it kind of creates kind of a very difficult legal scenario. So, but yeah, I mean, just generally though, that's a good thing to maybe make your landlord aware of too, if you're looking for some sort of terms to negotiate over. So.
So do you help people with that negotiation?
Yep. We've had a lot of people who are faced with non-renewals. So in that circumstance, there's at least a 28-day notice that's required of the landlord, and they'll come to us during that 28 days. So there is some time to extend the olive branch, so to speak. So. And a lot of these problems do just kind of arise from miscommunication sometimes.
Yeah. So would a non-renewal show up as an eviction?
If you hold over, so if you're non-renewed and you receive this notice and you stay after that non-renewal period, then the landlord is entitled to file for eviction against you, and then it would show up. So, yeah.
Is there verbiage that's required in the 28-day?
Well,
Just any notice at all, I guess?
It's pretty lenient on the notices. They do have to give you, they don't have to give you a specific date, but with the 28-day notice, it has to be at the end. It has to expire at the end of your renewal period. So if you're a month-to-month tenant and you pay rent on the 1st, then it has to expire on the 1st. So they couldn't give you one on the 15th saying the next 15th you have to vacate by. So, good question though. Anything else? No?
All right, I don't see any more questions. I do want to thank you guys for coming. I hope everybody got a lot of information. And again, we're glad that JATV is recording it so that anybody who couldn't make it here tonight is able to get that same information. So thank you.
Yeah, of course.
Thank you.